Good afternoon, everyone. I want to welcome you to the third meeting and the second public hearing of the Special Select Committee of the Senate on the Sexual Offences Amendment Bill 2019. This hearing is being broadcast live on Parliament Channel 11, Parliament Radio 105.5 FM, and the Parliament's YouTube channel, ParlView. I am Clarence Rambarat. I'm the chairman of the committee. The members of the committee are all senators. It's a committee drawn from the membership of the Senate. And we have with us, apart from the members, we have the Honorable Attorney General, who is the mover of the bill and who is entitled to participate fully in all the proceedings relating to this committee. I would now ask the other members of the committee to introduce themselves, starting on my right.
Good afternoon all. Gerald Ramdeen, member.
Good afternoon, Alison West, member.
Good afternoon, everyone. Paul Richards, member.
Good afternoon, Garvin Simonet, member.
Good afternoon. Welcome. Jennifer Witties Primus, member of this committee.
Good afternoon, Sophia Choate, member.
Good afternoon, Anita Haynes, member.
I would now ask the representatives to introduce themselves. We have 4 entities before us today, and these entities are the Office of the Prime Minister, Gender and Child Affairs Division, the Ministry of Foreign and Caricom Affairs, the Ministry of Social Development and Family Services, and the Ministry of Education. So I now ask the 4 entities to introduce themselves.
Jacqueline Johnson, Permanent Secretary, Office of the Prime Minister, Gender and Child Affairs.
Gayatri Paga, Senior Legal Advisor, Office of the Prime Minister, Gender and Child Affairs.
Savita Birbal, Legal Officer, Ministry of Social Development and Family Services.
Good afternoon, Jacinta Bailey Sobas, Permanent Secretary, Ministry of Social Development and Family Services.
Good afternoon, Rita Tusa, Acting Permanent Secretary, Ministry of Foreign and Caricom Affairs.
Good afternoon, Nicola Rosa, Attorney at Law, Ministry of Foreign and Caricom Affairs.
Good afternoon, I am Leno Batiste Simmons, Acting Permanent Secretary in the Ministry of Education.
Good afternoon, Avril Rahim, Director Legal Services, Ministry of Education.
Good afternoon, Vijay Gangapasad, Deputy Permanent Secretary, Ministry of Social Development and Family Services.
Good afternoon, Vidya Puran Singh, Director of National Family Services Division.
Good evening, Sabrina Peters, Senior School Social Worker, Ministry of Education.
Good afternoon, Kimberly Salvi, Senior School Social Worker, Ministry of Education.
Okay, thank you very much. As usual, we are supported by the staff of the Parliament in the form of our Secretariat. We are also supported by the representatives from the Ministry of the Attorney General and Legal Affairs, and that includes representatives from the Chief Parliamentary Council. I want to now invite representatives from the 4 entities to make some brief opening remarks, and we proceed in this order. Ministry of Education, Office of the Prime Minister, Ministry of Foreign and Caricom Affairs, and Ministry of Social Development and Family Services. Thank you.
Thank you, Chairman, and good day to members of the Special Select Committee. The current proposed amendments to the Sexual Offences Act, Chapter 1128, presents an opportunity for stakeholders to be part of the collaborative effort in crafting more effective legislation. The Ministry of Education, in its letter to the committee dated February 27, 2019, noted that the bill seeks inter alia to re-establish the National Sex Offender Register together with notification requirements, as well as to substitute the word and meaning of minor with child, consistent with the Children Act, Chapter 4601. The Ministry also requested clarification with respect to registration requirements relating to persons who are convicted of a registrable offense in Trinidad and Tobago, but who are neither nationals or residents, and the meaning and intent of Clause 43 of the bill with respect to when and what information will be removed from the website that is accessible to the public, and what specifically constitutes reporting requirements in this clause. The Ministry of Education viewed Circular Memorandum number 76 of September 2nd, 2008, outlined the procedures for all schools personnel re matters of child sexual abuse. The memorandum was sent to principals of primary and secondary schools, ECC coordinators of the ECCE, our Early Childhood Care and Education Division, school supervisors, as well as directors of the Curriculum Division and the manager of the Student Support Services. Also, the Ministry, through the Student Support Services Division, continues to provide the necessary intervention and support for students so affected, including those within the family of a perpetrator. The division also works in conjunction with the Ministry of Social Development and Family Services, the Children's Authority of Trinidad and Tobago, and the Child Protection Unit and Victim and Witness Support, both under the purview of the Trinidad and Tobago Police Service. With those few words, Chairman, I will pause and allow the committee to take the lead. Thank you.
Thank you. Office of the Prime Minister.
Good afternoon, Chairman. The Office of the Prime Minister supports this bill and see it as an important measure for addressing child sexual abuse in Trinidad and Tobago, given that 26% of all the cases of child abuse are child sexual abuse. Child sexual abuse has a devastating effect on the child, on children, the family, the community, and the society as a whole. So we look forward to a meaningful discussion on the bill today. Thank you.
Thank you. Foreign and Caricom Affairs.
Thank you, Mr. Chairman. Mr. Chairman, members. Thank you, Mr. Chairman. Mr. Chairman, members of the committee, ladies and gentlemen, good afternoon. And thank you for the opportunity to share the comments of the Ministry of Foreign and Caricom Affairs on the Sexual Offences Amendment Bill 2019. Such an issue is not normally something that comes within the purview of the Ministry of Foreign and Caricom Affairs. But having had the opportunity to gather and discuss the bill, we certainly welcome the chance now to share our views and our comments, as well as information that we received on similar provisions within other jurisdictions, which may prove useful at some stage in further consideration of the bill. Thank you.
Okay, thank you. And finally, Ministry of Social Development and Family Services.
Thank you, Chair, and good afternoon again to members. The Ministry of Social Development and Family Services is grateful for the opportunity to attend this stakeholder engagement session with the Special Select Committee of the Senate, and of course to provide our comments on the bill. The main objective, which we understood, was to allow for the re-establishment of the National Sex Offenders Register and the amendment of the notification requirements for registered sex offenders. We are particularly pleased that the bill is being discussed on the heels of our commemoration of International Women's Day on March the 8th. As you know, this is an opportunity to continue to raise awareness and engage discussions on gender-based violence in Trinidad and Tobago and other social issues which are key to the ministry's remit and to building a resilient, just, and safe society. When we consider the global estimates on violence against women published by WHO in 2017, which indicate that 1 in 3, or 35% of women worldwide, have experienced either physical and/or sexual intimate partner violence or non-partner sexual violence in their lifetime, or that some According to national studies undertaken in the U.S., up to 70% of women have experienced physical and sexual violence from an intimate partner. We understand that all necessary action must be taken to protect our women and children. Here at home, of course, the reported cases of rape, incest, and other sexual offenses, according to the Crime and Problem Analysis branch of the TTPS, indicates a 75% decrease between 2014 and 2015, but a significant 68% increase between 2015 and 2017. Of course, it means, and if we consider that 63% of sexual assaults are not reported to the police for varying reasons, we again understand the importance of moving on every front to protect our citizenry, especially our women and children. So our ministry, we are very happy to be here. Our National Family Services Division, mostly the main agency where persons are referred from the courts for counseling and so on. So I'm sure their contribution is going to be very useful. And finally, I would like to make the point that the ministry hopes that mechanisms would be put in place to measure the impact of this legislation, given that we are focusing on evidence-based policy and decision-making so that we will know whether the goals and objectives were met at the end of it all. So we look forward to the rich discussions, Chair. Thanks.
Thank you very much. I now want to invite Member Paul Richards to ask the first question.
Thank you, Chair. Good afternoon again, everyone, and thank you all for joining us. My first question goes to the representatives of the Ministry of Social Development and Family Services, and first, the Office of the Prime Minister, Gender and Child Affairs, because I know you work pretty closely together on issues like this. And let me say from the onset, I think I didn't see anyone in the Senate disagree with the principle of the amendment to the Sexual Offences Bill because of the heinous nature of one, criminal activity of a sexual nature, and two, when it relates to children and women. There were some contentious issues, and I want to start with the issue of the National Sex Offender Register, which is Part 3, clauses 37 through 55, which, while I agree with the issue of a national registry, there was quite a bit of contention on whether and how this should be applied. Based on the comments by the Office of the Prime Minister, Gender Affairs, and the quotation, and I'll quote, the October 1st, 2016 to September 30th, 2017 reveals that 4,232 reports of child abuse and maltreatment that necessitated investigation, 26.8%, or 1,134 cases were made in respect of child abuse. Of course, this is extremely serious, and some suggest because of the underreporting, this may be a drop in the bucket. You wholeheartedly, and I appreciate the fact that you mentioned in your commentary an evidence-based approach to policy making, because in the research I did, many jurisdictions around the world are rethinking the approach or the carte blanche approach to a nationally public registry without parameters. What are your thoughts on that? And do you think it may be more productive to have tiers or benchmarks for offenders, making this public, nationally available registry? Because again, we're balancing, first to me, obviously, the rights of the victim/survivor and their family, but also the rights of the person who has served their term and has the option to go back out into society and operate in a productive manner, in a rehabilitated manner. And in much of the research, the National Registry does not facilitate that. So first, the Office of the Prime Minister, and then the Ministry of Social Development and Family Services on that pretty contentious issue, please.
The idea of the registry is important for protecting our children and our women in communities. The issue of it being public is debatable, and Chairman, it's known that a public registry may do unintentional harm to some people. And as the member has indicated, yes, it can unintentionally harm those people who might have gone through a rehab process and are now fit to be among members of the community. It is debatable whether, based on our research, we can debate whether or not it benefits, it seeks the interest of the human rights interests of an offender, or whether it suits the interests of the community. And you're seeing varying ideas within the literature. While our position might be to have it published, yes, for the adults, we certainly don't want such information on children to be made public at any time. So I would because the research shows varying successes and others where the thing is really not working, I would leave it like that and see what happens when we introduce the registry.
Thank you.
Thanks again. We have had quite a bit of discussion surrounding the public, making it public, the register public. We have agreed that it, could serve the interests of the community because people would be aware of who these persons are. Of course, we indicated also as we were discussing that there are other serious crimes such as murder and so on that also should require persons knowing that these people are wrong. But generally, we agreed that it could be made public, but we also made the point that in terms of restorative justice, it might be counterproductive because we have a thrust towards restorative justice and also the whole reintegration of the offender back into the community. We are a small country, and it's going to be difficult for that person to reintegrate after their names are made public on a register such as this. So we have had the debate in the ministry, but we agreed that we would lean towards making it public and agree that not the children.
Right, I agree with the rights of the victims/survivors and their families should be paramount in this conversation or this consideration. But very often we approach these issues in an absolute manner, and everyone is included in one broad brushstroke. Do you think it would, based on both your experiences and your expertise and your discussions, that we can have several tiers for persons qualifying for a nationally public registry, persons who are showing no sign of being interested in rehabilitation, multiple offenders, particularly heinous situations where children have been, in some instances, terribly scarred, and we can decide upon those benchmarks later on, as opposed to persons who may have had one offense. And I'm not minimizing the damage that one offense can have in any way, because I know the public is looking, and this is a very passionate issue. But certainly we look at case by case and see what persons may certainly qualify for a nationally public registry because of what the history has been and the evaluation by trained professionals in evaluating that person as a possible ongoing danger to society in any way.
I will have our legal officer will respond to this.
Well, when I was doing my research, I looked into some of the other sex offender registries, public sex offender registries. I looked at the New York Sex Offender Registry in particular, and they have done something similar to what you're suggesting. So they have classified the offenders according to level 1, level 2, level 3, based on the level of the risk of reoffending as well as the danger to the community. So what they have done is that the level 2 and level 3 offenders are on a public website, public registry. The level 1 offenders are not on the public registry, but you are still allowed to get information from them, about them, by calling a toll-free number. And the information you get in relation to level 1, level 2, and level 3 offenders are more or less the same. but there is more extensive information on level 2 and level 3 offenders. For example, the level 1 offenders, when you call, you might just get the zip code, as opposed to the level 2 or level 3 offenders where you get the exact address. So we have considered the benefits of such a system, having regard to the fact that it may be difficult to get employment or housing if one is branded as a sex offender on a public register. So we do think that that is something that should perhaps be considered at this point in time.
Thank you. Just to end, Chairman, through you, and I agree with PS Jacinta Billy. So we may also want to consider domestic violence abusers to be entertained under that same system because of what we've had in Trinidad and Tobago, just to add to that. Thank you, Chairman.
Okay, thank you. We'll proceed in this order. Member Haynes, followed by Member Baptiste Primus, followed by Member Choate. Thank you.
Just continuing on the topic of the register, both the Office of the Prime Minister and the Ministry of Education noted that there would have been, they're aware that there may be unintended effects from a public register. And I'm looking at point 3 on the note submitted by the OPM, which speaks to that they will implement measures such as counseling and therapy to minimize its impact. The Ministry of Education stated something similar. The Ministry of Social Development noted that there would be human resources concerns. So I'd like to just start with OPM and the Ministry of Education to just kind of get some idea in terms of what's happening now with counseling and therapy, what's happening currently, if you have those numbers or statistics, and then how do you propose to facilitate an increased measure once this legislation, and similar question to the Ministry of Education.
And we are aware that there will be unintended consequences for the children as a result of the register. And what we are saying is that the support that you provide for the child should mitigate against the fact that the offender is on a public website. Now, this is the responsibility of the Children's Authority, and we have seen it happening already at our children's homes. Those children who are placed there because of sexual abuse, they have been receiving counseling and other therapeutic support. Yeah. It may not always meet the demand as we see it, but there are plans to provide additional resources in terms of psychologists, social workers, and we have been training caregivers to deal with some of these issues.
Through you, Chair, Ms. Salvery of the Student Support Services Division will provide an answer to that question.
Good afternoon, everyone. I'm currently at the Student Support Services Division. Victims as well as alleged perpetrators are receiving counseling from our trained social workers. Student Support Services is made up of social workers, guidance officers. We have the Special Education Department as well as the Day I unit, which consists of behavioral specialists and the clinical psychologists. So in instances like this, we look at the cases from an individual level, from a school level, as well as home and community. At the individual level, there is counseling that is provided for the students who may be victims of these issues. Also, at a universal level, the guidance officer will provide some universal type of intervention. Now, to note that these interventions are not just responsive, but they are also preventative approaches where even from at the infant level, the guidance officer will do topics such as good touch, bad touch for infants to be able to identify issues where they may be at risk. At the school level, there is teacher training on issues of Circular Memorandum 76, which mandates the teachers and anybody who has information of these type of issues to do the mandatory reporting, as well as how to identify that a student in your classroom may be a victim of abuse as well. Looking at the home and community, we have that family type of intervention. So we also do community engagement, parenting and education workshops, which is conducted by the school social workers, which would focus on a variety of topics, such as teaching parents how to identify warning signs of abuse. Also looking at if they are children who have been abused, how they can support those students at the home, because we at the Ministry of Education, the child is at the forefront of all our interventions. Thank you.
Just as a follow-up question, there are guidance counselors and social workers in every school, or is there a ratio of students to the guidance counselor?
No, currently they don't. At the secondary school, there is a guidance officer at each secondary school. And at the primary school, they probably have 3 to 4 schools. For social work operates on a 3 to 4 ratio at both primary and secondary.
And is there any plans to increase the numbers?
No, we do not have plans at this time. At this time, the complement of that division is over 800 officers. Yes, thank you.
Okay, thank you, sir. Member Baptiste Primus.
Thank you kindly, Mr. Chairman. I would want to speak to all the officers present here this afternoon representing the various government ministries. This issue that we are discussing, particularly public access to the National Sex Offender Register, is a very serious one, and one I believe will evoke the greatest amount of pushback. We are talking here about children needing protection. We are talking about sex offenders. Some of them are repeat sex offenders. Each one of us are parents. We have family members who are children. And we have to look at the situation. What would I want if my child is sexually harassed, if the offender is within reach of not only my child, but other children? So the question is, what are the benefits of the public having access to the register? Is it for the good of the greatest, in order to protect not only children who have gone through those experiences, but the children who are exposed? Having access, the public having access to the register, wouldn't it serve as a deterrent to other sex offenders or repeated sex offenders? Having the public access to the register, wouldn't such a situation arm the ordinary parent? And I'm not only talking about biological parentage here, parents, because we are all parents, whether biological or otherwise. Arm these persons with the necessary information to develop protective measures for the unprotected. I would like to hear a little more of the thinking of the senior public officers who assist us in very large measure in producing the kind of protective legislation. Why shouldn't the public have access to the sex offender register? I'm just pushing and asking for a response from all the officers here. I mean, you could weigh the rights. You could weigh the rights of the victim. You could weigh the rights of others. But what about the rights of the child or the children who are exposed? Do we take the risk and not make such information public? Chairman, I welcome the
Chairman, and this is one of the reasons why we are supporting the establishment of the registry, because our society is one where we know each other, most of us, every other person. But in the interest of protecting children and those women who are vulnerable, we need to be able to identify those who are sexual offenders among us. Now, I heard a member speak of the tier system, and maybe we need to consider that in terms of trying to protect the offenders' rights. But I think it's important for us to have a registry and for offenders to be known to the public. That's our position on it. And we agree that we do not wish to have a registry for the children who are sex offenders, but we are also saying that the police should have access to that child sexual register, not for public information, but they should have that compilation of data that someone could, that they or someone seeking information can gain access to.
Okay, thank you very much. I want to invite Member Choate.
Thank you, Mr. Chairman. I have a few questions. The first is for the representatives from the Office of the Prime Minister, Gender and Child Affairs. I make an observation before I start in that the focus seems to have been on women and children when sexual offenses are committed against persons of different genders. So I would not like our dialogue to be restricted to women and children. I do see, however, in the written note that you have provided that you have focused on registration of offenders who have committed child sex abuse. So my question is it that you think that those persons who have committed offenses against children should be prioritized for registration? And secondly, in your last paragraph, you say, you recognize the risk to a child who has been a victim where the publication of the name of the offender is made public. Now, in the case of an offense like incest, where it is going to be extremely easy for members of the public to identify who the victim is when members of the wider public, you say that there can be rehabilitation and effective recovery in relation to this unintended effect. But what is the basis for saying that? Has there been an opinion sought from a child psychologist trained in dealing with sexual offenses against children? Or is this just a hope that we have?
The answer to your first question is no. While our submission dealt with children, the protection extends to all forms of sexual gender-based violence. Yeah? So it's not for children only. We are seeking the protection as well for any other adult affected by sexual abuse. Yeah? The other question, yes, we did have our consultations at office with our 3 psychologists in terms of defining what exactly happens to children when they are affected by child sexual abuse. Yeah?
Thank you. Was there a report which may assist the committee?
We did. Sorry.
Thank you. I mean, subject to what the chairman has to say, would the Office of the Prime Minister be averse to sharing that information with us? Because that's really expert material that it would be useful for us to have.
We certainly will.
Thank you. Mr. Chairman, I don't want to take too much up of anybody else's time, but I do have some questions for the representatives of the Ministry of Foreign and Caricom Affairs. In your written contribution, you speak about the possible registration of persons who are non-nationals or residents who were minors when they committed a sexual offense but were tried as adults in their home. Now, the difficulty I'm having with appreciating this is because if we use the United States as an example, we may find that different states approach registration differently, but it's one country. So how is that practically going to work if we agree with this proposal?
Thank you for the question, Senator. That is certainly a difficult issue to manage and to address. We just thought that there are two things that you mentioned there. Well, persons who are not resident in this jurisdiction, but who have committed registrable offenses in their home jurisdiction, and those who were tried as adults. In terms of how it can work in Trinidad and Tobago, that raises other issues of the future of the individual. If the person was a child when the offense was committed but tried as an adult. There are concerns about what happens to that person as an adult on a register, but the fact of the matter is the crime is such that it is a registrable offense. I don't have an answer in terms of how it can work, but I think it is something that should be studied, considered, because it could be a reality that Trinidad and Tobago can face. And how do you treat persons who have committed registrable offenses elsewhere differently from citizens of Trinidad and Tobago who have committed registrable offenses here? But I don't have an answer of how it can work, how it can be implemented. It just came up as, I think, something that should be considered.
Okay, just one last thing. Was it that the ministry had any sort of expert input on this?
No.
Okay, thank you.
Right, thank you very much. I want to invite the Honorable AG to make a submission.
Good afternoon, everyone. Not quite a submission, but just following up on Senator Choate's inquiry just now and the ministry's response, which I thank you for. Is it that you're asking specifically whether we ought to contemplate including national children tried abroad as adults? Is it as simple as that?
No. We noticed that, unless I'm mistaken, there was not an addressing of non-nationals who were tried in other jurisdictions and were convicted of registrable offenses.
I can answer that insofar as it was a question.
Okay.
That would mean to register all people around the world onto our register. So what we've confined ourselves to is nationals and residents, because the residence takes you within the fold. So if we were to put a positive expression that non-nationals are to be registered, well, then we'd be doing a global registration in Trinidad and Tobago. So what we've done is we've confined the mischief to where it resides in Trinidad and Tobago.
Okay.
And then to the other point that I asked, and sorry for interjecting, with respect to the, our bill provides, just for clarity for the public, that no child offender has his or her information in the public. That's what the bill provides for. I've heard many people speak as if it is something to be supported. In terms of a recommendation, let's just to put it clearly, the bill says if you're a child offender, no public information. I'm asking, insofar as it's an interesting point, the Ministry of Foreign and Caricom Affairs has said, have we thought about the issue of a child offender who was tried abroad but treated as an adult? Is it your recommendation that in those circumstances, that child offender should be put onto a register which is public?
If our legislation or our approach is to not have a child offender on the register, then no. But I think it's something that has to be considered and decided on one way or the other.
Insofar as it was an inquiry and insofar as I'm the author of the bill, I can say that the bill intends that once you're under 18 years old, wherever you may have committed that offense, you are treated as a child, and that child offender will not be made public. So our position in relation to that, at least insofar as the bill is here, 18 stone cold, you're a child. If you're a child offender, nothing public. Whether you were tried as an adult abroad, etc., because then we would have to go into the parity of laws and whether another jurisdiction's renvoi or double renvoi from a criminal and civil perspective in some jurisdictional differences ought to be factored, and it would just be, quite frankly, too complicated in terms of a litigious approach. So we took a stone-cold approach on that to avoid the doctrines of international law, which would come to complicate renvoi or double renvoi.
Okay, thank you very much. Going back to the written submissions, the Ministry of Education has provided us with a written submission, and I now want to invite the Ministry of Education to make its submission, and I'm referring to the third paragraph of your written submission, where you are seeking clarification on a matter relating to nationals or residents, and you're also saying that you're unclear as to the meaning and intent of clause 41(3) of the bill. So I invite you to make your submission on that particular paragraph of your written submission.
Thank you, Mr. Chairman. First, the ministry in our discussions, we were wondering on the issue of neither national nor residents, whether, for example, undocumented migrants who may have committed a registrable offense, how they would be dealt with. Unless, of course, pursuant to their conviction, there's a detention and possible deportation, then the issue does not arise.
Mr. Chair, would you permit me?
Yes, please.
Thank you. We actually at the ministry, from a policy perspective and then prescription, looked at the requirement of whether a visitor to Trinidad and Tobago, who was therefore neither national nor resident, but who was entering into the jurisdiction and who had a conviction, ought to firstly declare that that person had been the subject of a conviction for a sexual offense, and then secondly, the mechanisms to cause reporting requirements. That presented, when we did a cross-jurisdictional comparison, that presented a number of challenges in terms of enforceability. What we did, therefore, is to hang our hat on the definition of resident within the context of the Immigration Act, Section 2 in particular. So we confined ourselves to nationals or residents, and that would take care of persons who were deported, because you're only deported back to your port of origin. So that would catch you for that reason. So we did not go into the transient person, nor could we go into the undocumented migrant, quite simply because they're undocumented, they're illegal. And once they're found to be illegal, then there's a mechanism to treat with that in law. So I hope that that lends some clarity.
Yes, thank you very much. It does. Yes. and it settles our issue. Moving on to the second issue with respect to the reporting requirements, when we looked at clause 43 of the bill, in relation to where a registered sex offender has completed his reporting requirements pursuant to this part, the information shall be removed from the website. We were wondering whether a reference to clause 47 that speaks to the entire reporting period in relation to Schedule 4 that details the reporting period commensurate with the crime wouldn't assist in clarity.
Sure. If I may, Mr. Chairman, we've used the language specifically reporting requirement under this part because Part 3 has multiple versions of having reporting requirements. It's perhaps immediately best demonstrated if you look at Clause 53. Clause 53 says, a registered sex offender may, A, on the completion of his reporting period, or, listen to this one, on the basis of any compelling reasons, apply to the court to have the information contained in the register in relation to him expunged. Now, that is a very significant clause because, number one, in relation to your question, it demonstrates that Clause 47 is not the only method by which you may report, and therefore we don't propose that we prescribe ourselves in relation to that clause alone. We've gone with the entire part to capture all permutations and combinations. But for the benefit of the public and perhaps for many senators, insofar as there's been a genuine discussion on the balancing of rights, in this instance here, the registered sex offender can apply to the court for any compelling reason to have the information moved and not present itself onto the register. Whether that needs to be thought of in a different combination in light of some of the discussions is perhaps something the committee may consider.
If I could just interject, following what the Honourable AG is talking about there, Mr. Chairman, is that also then possibly applicable to Clause 37A, which cites was convicted, well, let me read the first part. 37, the part applies to a sex offender who is a national of Trinidad and Tobago or a resident and who, A, was convicted of a registrable offence by a court within or outside of Trinidad and Tobago on or after the 25th of September 2000, which suggests the intention is to capture persons who would have been convicted in 2000. And if those persons, and the technocrats can also chime in on this, can also petition by some reason not to be included if the bill becomes law. If that also covers that.
Yes, so Clause 37 does kick into what we call the retrospectivity. There's a rule in law that you must be specific when you're treating with retrospectivity. It is not something that you run afoul of just because it's retrospective. However, the legislation is required to be precise. You must state that it is intended to be retrospective. We chose the date of September 25th, 2000, because from that date forward, there was a sex offenders register created. It just was never populated or operationalized in the way that it should have been. So we didn't want to go back to a time before which there was no known treatment for this type of condition. So yes, 37 operates, the entire Part 3 operates in tandem with each clause comprising the parts, and Clause 53 allows for that registered sex offender on the basis of compelling reasons to ask a court to say, don't put me on the register.
Okay, I just want to ask the Ministry of Education if there are any other parts of your submission you want to highlight for us. I just want to remind both the members and the entities before us, the purpose of the committee's work is not to deal with policy issues, but to address matters which are contained in the bill that is currently before the Senate. So if there is anything else you would like to highlight for the committee, Ministry of Education, you are now free to do so.
From our discussions, we do not have any other matters that we'd like to highlight at this point. Thank you.
Okay, Member Choate.
I'm wondering if you could clarify one thing for me. I was thinking about the proliferation of tertiary institutions and whether they fall within the supervisory ambit of the Ministry of Education. And if so, how are counselors provided on that kind of thing? Let's say a lecturer in a law school, for example, if they're who sexually abuses an adult student. Is there anything that the Ministry of Education can do?
At this point, the Ministry of Education is the tertiary institutions, university, UTT, COSTA, they fall under the Ministry of Education. But each of those entities deal with individual, if there are instances or cases. We have not looked at addressing in terms of counseling from the Ministry of Education, because most of the systems that we have in place at the Ministry treats with up to secondary level minors. Yes, that's what we have at this point.
May I assist as well? The charters of the respective universities and tertiary institutions, those that are associated with the Ministry of Education, fall from a financial contribution or management position. For instance, the Ministry of Education has a seat on the Finance Committee of the University of the West Indies, or the Attorney General may sit on the Council of Legal Education and have interaction in the law schools, the three of them across the jurisdictions. But the management of these sort of issues are outside of that ambit, and they fall within the charter arrangements of the respective entities as they come in, as far as I'm aware from the work that we do at the cabinet level in relation to the support services and facilitation.
Okay, thank you. The submission from the Ministry of Social Development and Family Services, you've raised at least 15 points. So I want to invite you to draw our attention to anything that has not been addressed so far, and anything you wish to raise with us based on your written submission. Thank you.
Thank you, Chair. Some of the issues have been raised here and have been clarified for us, but just on the point we were discussing a while ago under 37 with respect to the sex offender who is a national or resident and who was convicted of a registrable offense, either in a court within Trinidad or out. I'm just wondering how we are dealing with persons who were actually convicted outside. Is the onus on the person as they come back to Trinidad and Tobago to tell us, and if not? I mean, I'm just wondering what is the arrangement in terms of the networks with international agencies to get that information rather than leaving the onus on the person to say, you know, as they come in, I was, you know, convicted.
All right, thanks for that question. The Attorney General will address it because, in fact, a member of the public just sent me that same question to ask about the sharing of information and databases and how it's going to work in relation to this bill. Attorney General?
Sure, it's both actually. There is an onus upon the convicted who is a national of Trinidad and Tobago to inform of that position. And then it comes by way of reciprocal information exchange coming through the police entities, largely through Interpol. The only gap that really happens is where you don't have someone being deported, to explain the two different positions. Usually if a national of Trinidad and Tobago who does not have nationality in another country that is revocable, that is non-revocable, sorry, a national of Trinidad and Tobago that commits certain offenses in most jurisdictions and who doesn't hold nationality which can be revoked in that other jurisdiction, they are usually deported back to Trinidad and Tobago. And the process of deportation, there is a report, there's a marshal that brings the person back, the TTPS interviews the people at the airport, the particulars are taken. That's where entities like Vision on a Mission come in and they receive the deportees, etc. That's where you get the information and there's an existing mechanism for that. The other situation is where Say, for instance, someone is entitled to dual nationality, and that dual nationality is something which can't be revoked. For instance, the person was born in Canada to Trinidad and Tobago parents, and those parents brought the child's application for a passport to Trinidad and Tobago by virtue of Section 6 of the Immigration Act. That child would be entitled to Trinidad and Tobago citizenship, whether the child lived here or not. And once you acquired citizenship under 18 years of age, you'd have both nationalities. I'm using that example because had that person committed a crime in Canada, the Canadian authority possibly could not say, I'll revoke your citizenship because you are a citizen by birth. That child may have a Trinidad and Tobago citizenship and come here. It's in those instances that the national would have the onus, if it wasn't shared, of telling these things. So this isn't a perfect net where you can catch everyone, but it puts on a positive obligation into these requirements. I hope that assists.
One of the other areas that we were looking for clarification had to do with compensation, and we were just asking, you know, what the compensation would it be, what type of compensation would be considered, if it was, you know, medical expenses, loss of earnings, or so, and also in the event that the perpetrator isn't able to pay compensation because of economic situation, you know, what would be the situation?
The compensation is left to the discretion of the court. There are actually multiple pieces of law that provide for compensation. Where there is no direct payment, say from a person whose cupboard is empty, is bare, an indigent perpetrator, convicted person, there is, of course, that untapped compensation fund in Trinidad and Tobago, which is quite an interesting fund to be in existence and has been for many years. So there's criminal injury compensation that can happen. There are certain aspects of funding available in the mechanisms of Trinidad and Tobago, and there is, I think, perhaps a door yet to be properly opened in how that works itself out. Of course, there is nothing to say, as the bill does provide for the compensation mechanisms, there's nothing to say that the tortious aspect of it couldn't be managed as well. That is the civil law concurrent to the criminal law. We do contemplate that in the bill, and we do say that a court is entitled to have a look at whether compensation was paid by virtue of another mechanism as opposed to under this law.
Just one other point. I think we felt it was necessary to point out the need for all agencies involved, of course, to ensure that the human resource was in place for the implementation of this particular legislation, especially the counselors for persons, both the perpetrator and the victim, who would need to be counseled, and also the whole issue of the sensitive information in the register, even the part that is not actually made public, and the fact that people could hack into it and the implications of that. So I think that was important.
We do note, which is why we've put a proclamation clause. This law is coming in particular after the fact that we did the Family and Children Division, 23 amendments, 19 amendments, 13 amendments. We did a host of regulations, UN codes. We anonymized child records so that you don't have names for children, for instance, who are child offenders. There are UN codes. In fact, Trinidad and Tobago led the way in the Caribbean on these things. So we've had significant legislative and operational improvement, particularly in our court structures. We also come on the back of having operationalized the Children's Authority in a significant way and having put in the Child Protection Unit and other units in the TTPS, as you're aware, and in other ministries. But you touched something, Mr. Chairman, if you'd permit me. I wanted to ask one general question to every technocrat at the table, whomever is capable of answering. How many of you, in the professional capacities at the ministry, are aware of the ministry's interaction and treatment and counseling of the offender side of the equation?
I will ask my Director of Family Services to answer that because they deal directly with the courts, yeah?
I heard it from education, from accused potentials, but I'm interested in the others, just for the public's understanding.
Ms. Puransing.
Good afternoon again. Most of the respondents that are referred to us by the courts, and most of the referrals are from the magistrates' courts, they're out there as a result of domestic violence matters. We very rarely get matters of persons who offended or who have been the victims coming to us for counseling. And I would like to prefer that that's a different type of intervention, which would require a different type of professional, psychologist or psychiatrist. So the level of counseling that we offer, it's really for victims of domestic violence and the perpetrators. If we see that there is need for a different level of intervention, we do make referrals to the Health and Wellness Center, that's the psychiatric clinics at the various health centers. So we would see them at the rudimentary level. And then once we make an assessment, we also inform the court of our findings, and we do make the referrals.
Thank you, Mr. Chairman. Thank you very much, Ms. Puransing. If I may ask Ms. Birbal a question, insofar as she referred to a very useful example of analysis in New York, where there was a tiered approach to offenders. Much of the tiered approaching that I have come across in my own research and the ministry has been in systems where there are parole arrangements which require constant supervision and monitoring and assessment at the prisons level, and secondly, where there is an established running system of offender management, convicted management of a different type of psychological intervention. In your research, have you come across any tiered system where you have level 1, level 2, level 3, in circumstances where you don't have what I just described? In other words, then, where there is an absence of offender psychological management?
No, all the research I have done, there has been some significant risk assessment done for the offenders. So there has been another system in place.
Which would allow the ability to reoffend, etc.
To be assessed more clearly.
Thank you very much. Thank you, Mr. Chair.
Okay, thank you. Before I go to Member West, I just want to ask Ms. Puransing, what are your, I expressed some views during the debate on this bill in the Senate on this issue of underreporting. And I made the point that, you know, I've spent most of my life in my community, Mayaro, Rio Claro, Biche, Navet, and those communities. And I believe that part of the experience is that sexual offenses and sexual abuse relating to children in particular, they're not reported in the numbers that they should be reported. All offenses should be reported. But I believe is particularly chronic when it comes to sexual offenses in relation to minors in particular. What has been your experience?
In most instances, it will be as a result of, even if they share informally without going to the police, it's because of fear or shame of others knowing, and that's a real issue that a victim deals with. Also, it has to do with economic dependence. For instance, if a female is being sexually abused in a household, but that female is economically dependent on the offender, then in some cases there's a tendency not to report. So, but generally it's out of shame and out of fear that they hesitate to make reports. And also sometimes the system, because you know, some persons would have gone maybe in the first instance to make a report, and at times persons are not being taken seriously. Like a report, an official report is usually not made, or a receipt is not being given. So, you know, it depends on how it's interpreted. So there are different reasons, but I want to say generally it's out of shame and out of fear.
Thank you very much. I invite Member West.
Thank you, Chair.
Chair, I direct this question to Acting PS Tusa from Ministry of Foreign and Caricom Affairs. In light of your suggestion that we consider registering non-residents and non-nationals, the AG did, in his addressing that issue, indicate that there is a gap in terms of information that we will not catch. I'm wondering whether you have any experience of receiving requests from other jurisdictions about Trinidad and Tobago offenders who may be visiting or living in those jurisdictions, and if so, how did you respond?
No, I do not have recollection or record of such requests that I can mention at this time. But in terms of offenders from other jurisdictions coming in, while there might not be information shared by another jurisdiction's agency, it is difficult to get someone to, it's impossible to get someone to declare status of that nature on arrival. But such information can be possibly captured at the point of visa application. And that's probably only a small group of people possibly, but that is one way it can be captured. In other areas, possibly maybe even random interviews by immigration on arrival. It is not an easy thing to capture, that information, because no one wants to say, I've been convicted of this crime. But there are examples of countries using the visa application process as one method of getting such information.
May I just also assist with the Advanced Passenger Information System and the harmonized Caricom single market approaches, etc. We now have Interpol Blue Notice, Red Notice, and scrubbing of information as our databases are now married into one. So Trinidad and Tobago is tying into the APS systems from the passenger information side, where we have a scrub of other databases that go through our Interpol arrangements. It's not something that most people are aware of, but it is becoming a very large aspect of screening for foreign terrorist fighters and other aspects, etc., so that we catch it even for non-visa applications, because there's some people who are exempted from visa applications. It does depend upon the interoperability of police-to-police mechanisms and Interpol's position, but we do have that system here, and it is through the Ministry of National Security to be significantly improved very shortly, as we have just dealt with the database aspects of it.
Thank you very much. Member Baptiste Primus.
Thank you kindly, Mr. Chairman. This question is directed to Mr. Hussain, and I want to link my question to the responsibility of the Ministry of National Security in granting work permit applications to non-nationals. Is there a system in place to identify whether or not sex offenders are applying for work permits to work in Trinidad and Tobago? Is there a system in place where we can capture that information?
At this time, I don't think specifically for that, but certainly the work permit application process, I would think, could provide an opportunity.
If I could assist, work permits require certificates of character from country of origin, which deals with criminal convictions, etc., including charges in some jurisdictions. So no permit is granted unless the Ministry of National Security has received that certification from home territory. So it'll pick up all offenses and not just sexual offenses.
Okay. Thank you very much, Member Richards.
Thank you, Chairman. Through you, this question is to the Ministry of Education primarily, but certainly the Office of the Prime Minister and the Ministry of Social Development and Family Services can also chime in. I recently had the opportunity to attend and participate in a cybersecurity conference, which dealt primarily with terrorism, but also touched significantly on the issue of digital identities and the opportunities in cyberspace, where in Schedule 2, there are provisions for capturing email addresses and number 28, and information on IP addresses of any device regularly used by the offender. And if the Ministry of Education in particular is, because you mentioned earlier on, one of the officials mentioned earlier on, student education programs where you talked about good touch, bad touch. But good touch, bad touch is for a particular age demographic. And a large part of the school population is beyond good touch, bad touch. And they live in the digital realm. And if because this is what the part of the conference dealt with, a lot of the databases deal with digital identities and shared with I guess the Ministry of National Security and the Office of the AG, where the IP addresses, digital identities of offenders are shared with the Education Ministry and other stakeholders so that it is disseminated to students and users of groups, because it is a well-known fact that more than 60% or so of the identification, targeting, and grooming is now coming through online. And if the ministry is dealing with that digital aspect comprehensively, especially as is outlined in Schedule 2 and other schedules, with access to that information that can be disseminated, and so red flags in other jurisdictions go off on student computers and warn them, well, this person from this IP address may be a predator, etc. And if that is a consideration for the Education Ministry in terms of, one, student awareness, and the other ministries in terms of access to these digital identities for public awareness and safety. There's an opportunity now in the digital realm to immediately identify and red flag possible predators. And I don't know that we're going that way. And with the inclusion of these digital domains and IP addresses and email addresses, we can go one step further and put digital identity profiles online, and students and public has access to that.
I'm listening, and I think it sounds fantastic, but it is something that is relatively new to me. I don't know if my colleague, Rahim, we'll consider it, we will look at it, and then as we know, because in our schools, most of the time, in some schools, students are not allowed to utilize their phones at school, but at home. But we will look at it, because at least, as you say, it's a digital realm, and our students live there. So it means that they will be able to access the information. But at the end of it is the interpretation. How, if in case we are able to send them, as you said, create a profile, which we can do, but if in case they pick up someone who is not really a sex offender, how do they treat with that? So it means that we would have to consider it and communicate with the Ministry of National Security.
That was also part of the discussion at the forum, and the participants or the professionals erred on the side of caution. If someone used a particular computer and an IP address came up, it is a warning that maybe not in a confirmatory manner, but it's certainly cause for concern that perpetrators are using this computer or this IP address to get access to young people. So it's not a definitive identification, but certainly law enforcement and other agencies may be alerted to that access coming from that person. And then certainly email addresses, digital photographs, all types of all forms of digital footprints of perpetrators can be gleaned, and you get a sense, because we're talking about a national registry in a kind of old school way sometimes. And when we're moving towards more of a full digital realm, particularly for the vulnerable groups that we're discussing here today. So that's why I brought it up as a consideration.
Thank you very much. Thank you.
Okay, thank you very much. I wanna just outline how we're going to proceed from here on. There is one matter I want to invite Social Development and Family Services to raise with us, and that is, you've made a recommendation about expanding the information to be provided in relation to the addresses. And you've made a recommendation, and I just want you to expand on that a little bit for us. But before I give you that opportunity, I want to invite Member Choate and when we're finished with Member Choate, I want to invite Ministry of Foreign and Caricom Affairs to make any closing submission you would like to make to us. So, Member Choate, followed by Social Development and Family Services on that particular recommendation, followed by Ministry of Foreign and Caricom Affairs.
I have a question for the representatives of the Ministry of Education. Your last answer caused me to think about something, which is to say, how does a ministry liaise with the Ministry of National Security in relation to matters such as these? I mean, is it on a sort of ad hoc case-by-case basis, or is there a committee that meets and discusses matters relating to these issues on a regular basis? How do the ministries interact?
The Ministry of Education, through the Student Support Services Division, meets. I can ask my representative how often I'm to this. So, Ms. Peters or Ms. Sandri, thank you.
Good afternoon again. We normally liaise with CPU and the Ministry of National Security on cases. However, what has been initiated in some districts is there is a collaborative group among stakeholders that are engaged in these type of issues, and they meet regularly. Sometimes we do school visits together collaboratively, which we call a school caravan, and we would go into various secondary schools and highlight various issues and so forth. Sometimes we collaborate as well in terms of meeting with these agencies to discuss how we can collaborate and move forward in addressing these issues together. So it's something that is done, but in terms of that collaborative meeting regularly, that is something we are pushing forward more at this point in time.
Okay, thank you very much. So I would now invite Ministry of Foreign and Caricom Affairs to draw to our attention any other matter you wish to raise with us, and then I would ask any of the other three entities if there is any other matter you would want to raise with us as we draw to a close. I also want to remind you that you're free to provide us with any follow-up submission in writing you would like to share with us, or raise with us in writing any matter you feel that you want us to address. Thank you. Yeah, right.
Yes. Thank you, Mr. Chair. There is no point out of the Ministry of Foreign and Caricom Affairs submission that I wish to raise at this time, except to say thank you for the opportunity to participate in this engagement. Thank you.
Thank you. And Ministry of Social Development and Family Services, I will invite you to address that particular issue I raised in relation to your submission, and any other contribution you want to make as we close.
The legal officer will take that issue up, and then I will just give my contribution. Thanks.
Thank you.
In relation to the submission, with regard to the main address is defined as the place in Trinidad and Tobago where the registered sex offender resides permanently or habitually. This was just a small issue that we had, the fact that the place is singular as opposed to plural. So what it is that the legislation as is just asking for one address. But if an offender habitually resides somewhere, there may be more than one place where he habitually resides. So we were just stating perhaps that it might be prudent for the sex offender to give multiple addresses where he can be found.
May I refer you to Schedule 2? Main address or secondary address, address of any other place where he visits regularly. That captures everything.
I recognize that in your written submission you've recognized secondary address.
Yes.
But what you're saying is beyond that, there may be several primary addresses.
Yes.
Yes. All right. Okay, thank you very much.
Just to...
Back to...
Yes.
Yes.
In closing, just two issues. We spoke to the non-nationals coming into the country, I note that our nationals, as they go out, their passports will be stamped so that even as they go into other jurisdictions, they will know that they're coming in. And I was wondering if that goes the other way, that once the country has a register, we will know that the person is a sex offender, because similarly their passport will be stamped, and we could pick it up like that and at least inform national security, at least those where there is a register from their country, I'm thinking. And just to say, to ensure that this legislation is actually as effective as it could be, we will need to certainly ensure that the perpetrators get counseling, because that's the only way they're going to really be deterred. The deterrent is not that other people know, but they're not going to be deterred simply by this. There has to be some rehabilitation and some counseling, and the community must also be made aware of this register and these persons being on the register if the legislation is to be as effective as it could be. So in closing, we thank you again, Chair, for the opportunity.
Thank you very much. And I just want to make the point that in other jurisdictions, there is the requirement to have the record made in the passport. The matter of counseling and resources is something that in the previous public hearing it was raised, and in many of the contributions we have in writing, the issue of support services in the community and in the homes have been raised with us. I want to invite education, if you have anything further, and then the Office of the Prime Minister.
As the Ministry of Education, we thank you for the opportunity to listen and to collaborate in this stakeholder meeting. We have, again, I learned about the digital photograph and the digital footprints, and that the ministry can work along with the Ministry of National Security for us to look at that in terms of protecting our children at the various levels. We have heard with respect to that maybe a tiered system as opposed to the absolute approach with respect to the registration, that again, we feel that the human resource requirement we would have to address at the Ministry of Education. We may have to look at it. We may have to begin to look at different types of offices that maybe we would have to create to be able to address if this if it goes forward in terms of the bill. And again, let me just say thank you so very much for being here. Yes.
Thank you. Office of the Prime Minister.
Chairman, I just want to make 3 quick statements. One, that we need to put in the infrastructure necessary to deal with victims and perpetrators. We have done a lot for the children and how we deal with them with sexual violence and how we treat with the perpetrator, and we need to do a similar thing for the adults. Member Richards asked about the cyber issue, and that is a issue that is being discussed with a committee set up to deal with child pornography. How do we alert children about possible perpetrators of such crime? Thank you.
Thank you very much. I want to thank the representatives of the Ministry of Education, the Office of the Prime Minister, Gender and Child Affairs, the Ministry of Foreign and Caricom Affairs, the Ministry of Social Development and Family Services. I want to thank the members of the committee, the secretariat provided by the Parliament, the representatives of the CPC, and the Ministry of the Attorney General and Legal Affairs. Most importantly, I want to thank the viewers and the listeners who are following us. If you saw some of the members with their phones, it is because a number of members of the public have been sending messages and asking questions, some of which were relayed to me, and some of which the members are answering as they receive the message. This topic has generated a lot of interest in the public domain, and we are very, very grateful for your attendance and your support in providing clarification and also giving us an opportunity to provide clarification. This meeting is now adjourned to Tuesday, March 12, 2019 at 10 a.m. Thank you.